Burglary to a conveyance is the legal description of a crime more commonly referred to as auto burglary. Common examples of a conveyance as defined by Florida law include motor vehicles and boats. This offense is categorized as a felony of the third degree. It carries penalties of up to 5 years in the Florida state prison system and up to a $5,000 fine. Given the threat of incarceration and the ramifications of becoming a convicted felon, it is imperative that you speak with an experienced lawyer if you or a family member are charged with this offense. The prosecutor must prove that you entered the conveyance with the intent to commit a crime once inside. In other words, breaking a car window might constitute the misdemeanor offense of criminal mischief, but would not rise to the level of a burglary. Removing tires and rims from a car would be appropriately charged as a theft offense, but it would not lawfully constitute the offense of burglary since it lacked the critical element of entry. Now, if someone enters a conveyance without the permission or consent of the owner and thereafter removes personal property, they can also be charged with petty theft if the value of the property was under $300, or felony grand theft if the value of the stolen items reaches $300 or more. The facts of each burglary case are unique. For example, at an initial consultation, we will want to know if the police are likely to have secured matching latent fingerprints from the vehicle. Did you simply exercise bad judgment because you were impaired by alcohol or drugs at the time of the offense? Did you actually enter the vehicle, or did you play a lesser role, such as simply acting as a lookout? Given the facts and circumstances of your case, we will decide if an early intervention with the prosecutor could be successful in persuading him to limit the number of formal charges or to file a lesser offense. The criminal defense attorneys in our office routinely represent clients charged with these offenses. Our clients are sometimes arrested for a single criminal episode that involved the burglary of more than one automobile. In some cases, the vehicles had been left unlocked by their owners. Common items taken often include GPS devices, MP3 players, and cell phone chargers. Surprisingly, some thefts involve items of little monetary or sentimental value. For example, sunglasses, CDs, ball caps, or loose change. You should know that the unlocked nature of the vehicle, the lack of physical damage to the car, or the insignificant nature of the property taken does not constitute a legal defense to this crime. Nevertheless, we often use these kinds of factors in our effort to limit the number of charges filed, mitigate the punishment, and to avoid a formal felony conviction. Obviously, making the victim whole by either returning the property or compensating him for his loss can also go a long way in achieving the best possible outcome. If you've been charged with burglary to a conveyance, we can help you in several different ways. Talk to us about your eligibility to participate in the PTI Diversion program, which is designed to result in the dismissal of your criminal charges. Learn how a withholding of adjudication can prevent you from being a convicted felon, and the criteria for the sealing of criminal arrest records. You are invited to schedule a free consultation so we can discuss the facts of your case and explore the best strategy for achieving the objectives most important to you.